Hello and welcome to part 2 of the Negotiable Instrument Act presentation. My name is Ravi Gupta and I'm going to move ahead with the emphasis on dishonour of check. In this presentation, we'll be discussing majorly five topics, that is dishonour of check, section 138 of the Negotiable Instruments Act, grounds on which a check can be dishonoured, legal rights of payee after check is dishonored, statutory procedure to be followed, and in the end, liability of partners and directors of a company. So, what is dishonor of check? A check bounce, as we call it in normal parlance, or a dishonor of check is a situation or circumstance where one person presents a check in a bank which is not honored or which gets rejected on certain grounds. These grounds can be numerous, which we'll be discussing in the coming slides. Section 138 of the NI Act deals with the dishonor of check. It addresses circumstances where the check drawn is for a dizzy discharge of an existing liability or debt by another person. Next, we have grounds on which a check can be dishonored. According to Section 138, there are primarily two reasons on which a check can be dishonored. One is insufficiency of funds, and second is when the amount exceeds the arrangement made with the bank. However, there are several other reasons on which a check can be dishonored or rejected, such as payment stopped by the drawer. Second, the check may be of post date. Third, account is closed, and so forth and so forth. So, in cases of dishonor of check, what are the legal rights of the payee? There are primarily three rights which a payee can avail. One is complaint under Section 142 of the NI Act. Another is a civil suit of recovery of money. Third is criminal complaint can be filed under cases of cheating or breach of trust or forgery, etc. Now, what is the procedure to be followed after a check is dishonored? Section 138 of the Negotiable Instrument Act provides the following steps to be taken after dishonor of check. First is notice of dishonor. Within 30 days of the receipt of the information of dishonor from the bank, a notice of dishonor has to be sent to the drawer according to the provision of Section 138B of the Negotiable Instrument Act. Now, this notice has to cover three major averments. First is a statement of dishonor. The notice should clearly explain that the drawer's check has been dishonored by the bank due to the grounds mentioned in the Negotiable Instruments Act. The next head is payment demand. The notice should specifically make a demand from the drawer to pay the amount within 15 days of the information receipt. And the last head is intention to file a complaint. The notice should unequivocally state that the drawer's intention is to file a complaint in case the drawer does not make a payment within 15 days of the receipt of the notice of dishonor. The next step is to file a complaint case. In pursuance to Section 142 of the Negotiable Instrument Act, a bar has been created against taking the cognizance of the offence under the Section 138 unless a written complaint has been filed by the drawee or the payee within 1 month after the occurrence of the underlying cause of action. Next is jurisdiction. The case has to be filed before a court of metropolitan magistrate or a judicial magistrate of first class with appropriate jurisdiction of the bank branch where the account of the drawee is maintained. Next is court proceedings. Once the case is filed, the court will review the pre-summoning evidence, and upon reviewing the same, the court will issue summons against the accused person if the court deems that all necessary conditions have been fulfilled in accordance with the Section 138. Next is summary trial. The trial of the dishonor of check shall be conducted in a form of summary trial. In pursuant to Section 143 of the NI Act, offences punishable under Section 138 of the Act are to be tried by the judicial magistrate of first class summarily and in accordance with the provisions of Section 262 to 265 of the Criminal Procedure Code. This means that any trial conducted in pursuance to these sections has to be finished quickly or completed quickly and as soon as possible, and within 6 months of the day of filing the complaint. Last is punishment. In case the drawer is found guilty of the offence under 138, then the punishment imposed on him may vary from an imprisonment up to a term of 2 years, a fine which may extend to 2 times of the check amount, or with both. The court may also order the drawer to pay compensation to the payee. Next is a summary trial procedure to be followed for offences under Section 138 NI Act. Step 1. Once the case is filed and presented before the concerned judicial magistrate, first class, or the metropolitan magistrate, the court will scrutinize the complaint along with the document. And once it is satisfied that the offence of dishonour of cheque is made out, the court will issue summons to the accused. On receiving the summons, if the accused appears, the court will ask the accused to furnish bail and take a notice under Section 251 CRPC. And at this stage, the court will also ask the accused to enter his plea of defense, and thereby the court will fix the case for defense evidence. However, at this stage, an application can be made by the accused person under Section 145(2) of the NI Act for recalling of the witness for cross-examination on plea of defense. Next is, if there is an application made by the accused person under Section 145(2) of the NI Act, the court will decide the same and will proceed the case for defense evidence on record. Upon completion of the defense evidence and cross-examination, the court will then hear the arguments from both the sides, and once the court is satisfied and apprised on the law points and factual points, the court will then pass its judgment. Next, we have liabilities of the directors or partners in case of dishonour of cheque by a company or a firm. Now, Section 141 of the Negotiable Instrument Act prescribes that a person in charge or responsible for the day-to-day activity of the firm or the company is ipso facto, that is, by the fact itself, liable and regarded as guilty only if the offence is done with his consent or he has the knowledge about the offence being conducted. Now, to conclude, a check has to be presented within a specific period of time, that is 6 months from the date on which the check is issued. And once the check is dishonored, within 30 days from the receipt of such information, a demand notice has to be sent to the drawer in accordance with the Section 138 of NI Act. In case the drawer of the check fails to make a payment within 15 days from the receipt of the demand notice, a complaint can be filed in accordance with Section 142 of the Negotiable Instrument Act within a period of 1 month from the date of the cause of action that has arisen. Thank you and have a great day.